Welcome. This is the first in a series of 4 webinars looking at aspects of criminal and compliance investigations. Before we begin, I'd just like to say that I've placed you all on mute to aid sound quality. This isn't to bar you asking any questions. If you do wish to ask any questions, you'll be able to do so using the chat function, which should be on the left-hand side of your screen. Depending on the number of questions we get going forward, and I'd welcome them at any time, this webinar should last for about 30 minutes. So today we'll be looking at private prosecutions. In recent weeks, the concept of private prosecutions has been hitting the headlines, particularly with the families of some of the victims of the Glasgow bin lorry accident suggesting that they would bring a private prosecution against the lorry driver himself. Private prosecutions can be brought in respect of any criminal conduct. For example, in respect of murder, all the way down to breaches of criminal regulations. And there are examples of these having happened in the past. There are some crimes where a private prosecutor would find it very difficult to bring and conduct prosecution. For example, CPS guidelines state that it should take over all private prosecutions for rape unless there are exceptional circumstances. But today, and for businesses generally, the major source of possible private prosecutions is fraud. And why is that? Because businesses are and still remain the major victims of fraud. The 2013 fraud indicator, annual fraud indicator from the National Fraud Authority indicated that the UK economy suffered £52 billion as a result of fraud. That's a lot of money, obviously. So, why might private businesses be interested in private prosecutions? Well, there are 2 reasons. The first is that, increasingly, both police forces and CPS respond to criminal complaints by stating that there is not enough evidence to continue. Well, in any individual case, this might be because, genuinely, a thorough investigation has not generated sufficient evidence to bring a prosecution. But that can't explain the trend. The general increase must be in response to, 1, falling budgets, as some of these headlines we've taken from a range of publications demonstrate, and 2, a police focus on certain narrow core areas to the exclusion of others, probably in response to their falling budgets. The second reason why businesses might be interested in private prosecutions is that, under the right circumstances, it offers some advantages over civil proceedings, an issue which we will focus on in today's webinar. I am Ben Pilbrow. I'm an associate in Shepherd and Wedderburn's Commercial Disputes and Regulation Division, and I have a broad experience of assisting clients in a range of civil and criminal cases, and in particular fraud cases. So what are we going to look at today? I hope you will come away from this webinar with 2 things. Firstly, a general understanding of what a private prosecution is, and broadly, how one would go about initiating and prosecuting one. Secondly, I hope you come away from today with an idea as to the practical advantages and disadvantages of private prosecution compared to civil proceedings in relation to fraud claims. Hence, the webinar will start by looking at the jurisdiction for bringing private prosecutions and the practical procedural steps involved in bringing them. The webinar will then go on to look at the benefits of a private prosecution. I'll try to highlight how the introduction of the Fraud Act 2006 has made the case for proving fraud both simpler and applicable in a wider range of situations. We will then investigate the principal benefits of private prosecutions compared with civil proceedings. Those benefits are broadly twofold. Firstly, the criminal confiscation and compensation regimes have the practical effect of relieving the victim of the burden of enforcement that they would normally face in civil proceedings. And secondly, under the right circumstances, private prosecutors can be recompensed for their expenses of prosecuting privately from central government funds. To finish, this webinar will look at the issues that private prosecutors face generally. Now, the principal issue that we will look at and that has been troubling the courts recently is the fact that private prosecutors may, and often do, have a financial interest in the outcome of the prosecution. The law is still firmly on the side of the prosecutor in this respect, but the potential for conflicts of interest has led some judges to express unease at this fact. In addition to looking at this dichotomy, this conflict, we will also look at the loss of control that is inherent in bringing a private prosecution comparative to bringing civil proceedings, something that those who are not used to private prosecutions or the criminal justice system generally might find a little uncomfortable. That loss of control also includes the right of the CPS to take over prosecutions, whether to continue them or to discontinue them. And we'll be looking a little at that issue as well towards the end of the webinar. So, to start, how has the jurisdiction for private prosecutions arisen? Well, the recent press interest in private prosecutions suggests that the concept is a relatively new one. It is not. Indeed, the right to prosecute initially was entirely private. Before the establishment of the modern police forces, all prosecutions had, by necessity, to be private, because there was no public authority to undertake them. But with the inception of the modern police forces, there has been a historical trend towards public prosecution, which culminated with the inception of the CPS in 1985. The underlying legislation that created the duty of the CPS to undertake all prosecutions instituted by the police or prosecuting authorities also maintained the right of private individuals to bring prosecutions. In England and Wales, that legislation is Section 6 of the Prosecution of Offences Act 1985. Now, again, talking about England and Wales, since that act, various defendants have sought to challenge the effect of the legislation as a means of defeating charges brought against them by a private prosecutor. These challenges have routinely been dismissed, with the courts describing the right of individuals to prosecute as a valuable constitutional safeguard against inertia or bias. The same cannot be said about the attitude of the Scottish courts towards private prosecution, potentially unfortunately for the families of the victims of the Glasgow bin lorry accident. Now, I am not a Scottish qualified lawyer, but my Scottish qualified colleagues inform me that in the entirety of the 20th century, there have only been 2 recorded attempts at private prosecutions, one of which was in the 80s, and the second of which was in 1908. Both were rejected by the Scottish courts. That having been said, more recently, there has been a bit more interest in private prosecutions in Scotland. There is an appeal currently pending regarding a recent refusal of the Scottish Criminal Appeal Court to allow a private prosecution to continue, and that one would expect will go to the Supreme Court and we'll have a bit more clarity on it. My own view is that the same budget constraints that the forces of England and Wales and the CPS face are faced by their counterparts in Scotland. And therefore there is a public policy reason why perhaps the constraints against private prosecution in Scotland should be loosened a little, even if that weren't to open the floodgates. In England and Wales, private prosecutions are not that rare. I haven't been able to find out any statistics about the number of private prosecutions that there are annually. That may well be a symptom simply of how common they are. They are treated in the same way as public prosecutions. They are named, or they are brought in the name of the Queen, and looking at public records, there is no means to identify whether a claim was brought privately or publicly, without going into judgments, etc., or looking at the appeal courts. Now, private prosecutions can be brought either by individuals or by companies. And for a company to bring a private prosecution, all it needs to show is that it has a sufficient interest in the outcome of the prosecution. Indeed, companies are the major institutors of private prosecutions in England and Wales. For example, take the Federation Against Copyright Theft, or FACT. Now, you'll have seen their logo at the end of most films and on the back of most music albums. And many people think that FACT is a government body, or at least a government-sponsored body. It's not. It's a private company funded by the music and the film industry. Notwithstanding its private status, FACT brings many prosecutions in this country. In fact, I understand that FACT has a division focused solely on investigating and prosecuting copyright infringements. And that division is staffed by former policemen. So in many practical ways, it is indistinguishable from a prosecuting authority. Equally, the RSPCA commonly brings prosecutions relating to breaches of animal husbandry regulations, and it equally is well set up to do so. Now, obviously, these are institutions that are focused and a core tenet of their, I won't say business model in respect of the RSPCA, but their raison d'etre is to bring private prosecutions. But that is not to say that other companies that don't have a similar aim should not bring private prosecutions under the correct circumstances. So, if a company has decided to bring a private prosecution, and we'll look at the reasons why it might do so shortly, how would it go about starting that process? The procedural steps behind starting a private prosecution are simple, in fact, possibly deceptively simple. The prosecutor must simply lay an information before a magistrate or a justice of the peace, and that information must be, firstly, in writing. Secondly, it should describe the offence or offences in ordinary language. Thirdly, it has to identify the legislation creating the offence. And fourthly, and most importantly, it must contain sufficient particulars to make it clear what the prosecution alleges. Now that's pretty simple. There are other constraints, or one other constraint in relation to timings, and that is in relation to summary offences. The information must be submitted to the court within 6 months of the commission of the offence. There is no such time limit in relation to indictable offences, but the regulations require that the information is submitted as soon as is practicable. So it seems at first blush that it is very easy to get a private prosecution underway, and it is. But there are some hidden problems for the uninitiated, and those really arise because of the discretion of the courts as to whether or not to issue a summons based upon that information. Now, the court will only issue a summons if it is convinced that, firstly, there is evidential sufficiency to establish the offence, and secondly, that the prosecution is in the public interest. Now, that is a test faced by the CPS when instituting a public prosecution. And it is not immediately an easy one to overcome. If it were, it would be able to anyone to issue private prosecutions and to abuse the system and the benefits that private prosecutions bring. Hence, and what I would stress before I get into the advantages and potentially the disadvantages of private prosecutions, to undertake a private prosecution, you need to do so correctly. And to do so, it really involves getting the right team to support you, and doing so for the right case. If the CPS intends to bring a private prosecution, it will normally instruct counsel to review the papers and to settle the information. A private prosecutor would be well advised to undertake the same precaution and to instruct, firstly, decent team, including solicitors and investigators, but secondly and most importantly, an experienced prosecuting advocate, because the courts have said repeatedly that it is the prosecuting advocate who has the responsibility to ensure that the court is properly advised of the situation and that the prosecution proceeds validly. Now, without the protection of an experienced and qualified prosecuting advocate, private prosecutors lay themselves open, potentially, to allegations of misconduct or abuse, which is obviously best avoided. Equally, they may find themselves under circumstances where either a summons is not issued, or if a summons is issued, the prosecution is taken over by the CPS and discontinued, or the prosecution is not successful, all of which will lead to a loss of the investment in the private prosecution by the company or business to date. So, if you're going to do a private prosecution, the take-home message is do it right. Get the right team and get the right prosecuting advocate to assist. So why might a company consider a private prosecution as opposed to going and instituting civil proceedings? The Fraud Act 2006 is one possible reason why, or is part of the reason why, a private prosecution rather than a civil proceedings might be better. The Fraud Act came about to try and clarify the somewhat difficult legislation that had existed up until its enactment, and to make it easier to bring fraud cases and also for juries to understand them. The Fraud Act sets out three possible offences: fraud by false representation, fraud by failing to disclose, and fraud by abuse of position. All three of those offences have a common theme. One, they require dishonesty with intent, and two, they require a gain for the perpetrator or a loss or risk of loss for the victim. The way the Fraud Act defines false representation failing to disclose an abusive position is extremely wide. For example, in relation to false representation, it's sufficient if the representation is untrue or misleading, whether it's as to law or fact, whether it's expressed or implied, whether it's a statement of intent to the person or to a third party. And it doesn't even need to be a person, so the statement of intent can be made to a computer. Equally, the failure to disclose information can relate to legislation, contractual information, the duty of good faith, and that is particularly important for insurance companies, or arise out of the obligation to disclose under a fiduciary relationship. Lastly, in relation to the abusive position, abusive position can be in relation to a person who occupies a position expected to safeguard or not to act against the financial interest of another person. And it includes omission as well. So you can see these are all extremely widely drafted, and they are all conceptually relatively simple. By contrast, the definition of bringing a claim under the tort of deceit, which is the civil proceedings equivalent, is that the defendant must knowingly make a representation, must be false or without belief in its truth or reckless as to whether it's true. There must be an intent that the recipient will rely upon it. The recipient then must rely upon it, causing loss. That is by no means an easier task, easier test to establish. And the second point I'd make in relation to the Fraud Act, or more particularly criminal versus civil proceedings, is the difference in the burden of proof. Burden of proof in civil proceedings is obviously on the balanced probabilities, whereas it's beyond reasonable doubt in criminal proceedings. But there is a number of court cases that have established that in civil proceedings, in relation to allegations of fraud, very cogent evidence is necessary to overcome the unlikelihood of fraud. And in many ways that increases the burden of proof in relation to proving fraud in civil proceedings, such that there possibly isn't that much of a difference between the two burdens. So, the test you'd have to overcome is perhaps easier, and perhaps the burden isn't quite as difficult. Are there any other reasons why one might choose to institute a private prosecution as opposed to a civil proceeding? Well, let's have a look at the civil enforcement regime before going on to have a look at the compensation and confiscation regimes that one has in the criminal justice system. In the civil enforcement regime, a claimant can, on an interim basis, apply to freeze a debtor's assets or apply to appoint a receiver over a debtor's assets. The first of these is not all that difficult, but requires a significant investment. Second of these is really quite difficult to persuade a court to do. It's easier for a judgment debtor to obtain relief, and he has more options to him. Obviously, he has a judgment in his hand. He can freeze a debtor's assets, charge a debtor's assets, appoint a receiver, or even sell a debtor's assets. However, all three of these require knowledge of the debtor's assets. They also require significant investment, and in relation to the freezing orders and the interim receivers, they usually require a cross undertaking. Now that is something that a company may not be willing to give, particularly under circumstances where they have no knowledge of the debtor's assets. in civil proceedings, how can you go towards establishing the extent of a debtor's assets? On an interim basis, the major way, beyond paying investigators to do so for you, is to obtain the affidavit in response to a freezing order. Post-judgment, a creditor can apply to have a judgment debtor examined under oath. But do these possibilities have teeth? Well, that's a good question. More and more the civil courts are making contempt judgments, but it is still very difficult to bring a contempt application, and it is even more difficult for that application to then result in any form of committal. By comparison, the civil justice system has an entirely different system for undergoing enforcement, though it wouldn't see it as enforcement. It has a compensation and a confiscation regime. What's the difference between those two? Well, a confiscation regime really looks at identifying the profits achieved by a defendant, a guilty defendant, and confiscating those from him. In contrast, the compensation regime really looks at the loss to the victim of the guilty defendant's actions. And that conceptual difference means that the two orders that a court might make may well be different. However, the court, in a number of cases, has stated that where there is not enough money for a confiscation and a compensation order, the compensation order should be taken from the confiscation order. So, in many ways, for the victim, financial recompense, which may well be its primary motive, is treated as a greater priority by the civil justice courts. So let's look at what the court looks at when considering making a confiscation or compensation order. The court is obliged to make a compensation order, obliged to consider making a compensation order whenever there has been a conviction. The court should look at what it is appropriate, having regard to representations of the victim and or the prosecution, as to the defendant's means, so far as they are known. And it should make a compensation order in preference to a fine. The only circumstances where it wouldn't be appropriate to make a compensation order is where there is any doubt that the defendant has caused the victim the damage complained about. In relation to a confiscation regime, the court must make a confiscation order against any convicted defendant if requested. As I say, a compensation order can be paid or should be paid from a confiscation order if the defendant cannot pay both. And the real teeth behind the compensation and confiscation regime is that breach by the guilty defendant results in prison. If there has been breach, the court is obliged to impose a consecutive minimum term of imprisonment in default. That will be in addition to the term it imposes in relation to the offence for which the victim has been found guilty. Now, here in this table you'll see how long that term will be. The figures and the dates here serve as minimum as well as maximum. So, for example, if a defendant is found guilty of causing damage of £75,000, the maximum consecutive term of imprisonment that could be imposed is 2 years. But equally, the minimum term that can be imposed is 18 months as being the highest in the lower brackets. Additionally, there is no time off for good behaviour in relation to the consecutive term. So whether or not his term of imprisonment is reduced in relation to his substantive conviction, if he doesn't pay the compensation and confiscation orders, he will have to serve the full term of his confiscation order imprisonment. Equally, if he serves that full term, it doesn't actually undermine the underlying liability. So if he thereafter wins the lottery, the victim can still make sure that the confiscation order and compensation orders have teeth, notwithstanding the fact that he might have served a significant term of imprisonment as a result of failing to pay it previously. So, how does one calculate a confiscation order? A confiscation order is limited to the lower of the benefit or the available amount. The benefit is the gross receipts as a result of or in connection with the offence, with an RPI uplift in relation to inflation. Whereas the total assets of a defendant are what the available amount is. Hence, if you have a defendant who has squandered many of the gross receipts, the available amount is going to be lower than the benefit. But the onus is on the defendant to establish the available amount. And if the defendant does not discharge that onus, the court may and should make an order for hidden assets. Now, this is the real difference between the criminal compensation regime and the civil proceedings regime. It switches the onus from the claimant, stroke victim, to the defendant. The second reason why there is potential benefit to a company or business bringing a criminal prosecution, private prosecution, rather than civil proceedings, is that under the correct circumstances, when successful, the court may order a private prosecutor's reasonable costs be compensated from central funds for any indictable offence. That might not sound that brilliant, but it really can have a benefit. Virgin Media brought a claim against a gentleman called Zinger, and there have been numerous reported cases arising out of that. But one of them related to the application by Virgin Media for costs paid out of central funds. And that application was rumoured to be in the region of excess of £1 million. So if you play your cards right, you can find you are in a very beneficial position where even if your compensation or confiscation order doesn't actually bring in what you expected it to, you can be compensated from a different source for the cost that you've incurred in bringing the matter to court. So that's all the upsides. What are the downsides? Well, as I say, there has been unease recently about the financial interest of a private prosecutor having an effect on the outcome of proceedings. The problem has been recognised, but the court, both at first instance and on appeal, has been firm in the fact that a private prosecution is allowed and a compensation and confiscation order are part and parcel of the prosecution process. However, I think what might happen more, and what has been seen to happen from time to time, is that the CPS will enable a private prosecutor to take forward a prosecution until conviction. But if there are concerns about a private prosecutor having a conflict of interest in relation to the application for a compensation or confiscation order, the CPS will take over the conduct of that application. So that may well be a way of safeguarding. There are also concerns about the victim controlling or funding the prosecution. Now, these really relate to the same idea, that their financial interest will cause them to act inappropriately. There is possibly some merit in that, but if a business goes about a private prosecution in the right way, by putting together the right team and by having the right prosecuting advocate, it should not be a problem. Which rather defeats the last potential downside, which is, might the incentive or interest give rise to an abusive process? Indeed, there have been numerous judgments which have compared the prosecuting counsel to a minister of justice that show quite how much importance the courts place upon the role that the prosecuting counsel or prosecuting advocate has to play. So, when dealt with correctly, these shouldn't be a problem. Are there any other difficulties? Well, I've mentioned before that the CPS may well take over the prosecution of the private prosecution. Now, that could be a difficulty if they do so to discontinue the claim, but if that's the case, you really shouldn't have been instituting it in the first place. If they do so to take over the claim because they want to prosecute it, that is really a boon for the private prosecutor, because it means they no longer have to fund the prosecution. Other difficulties are the CPS and the other prosecuting authorities have the benefit of the police to conduct investigations for them. A private prosecutor doesn't have that, and there would be significant expenses in trying to get together the material to bring a case. That is really why a private prosecution is not something to be used willy-nilly. It really is for the right case. However, there's a flip side to this. The investigator isn't restricted by the Human Rights Act, or RIPA, which the police authorities are. So, swings and roundabouts in many ways. Is there going to be a change in the law? I don't think so, really. I think private prosecutions are here to stay. They're increasing in number, but I don't think that there's going to be a floodgates problem any time soon. And therefore, private prosecutions really is something that, under the right circumstances, businesses should contemplate as an alternative to bringing civil proceedings. So, there have been quite a few questions. David Ingram asked, could the CPS under freedom of information, could you ask the CPS under freedom of information how many private prosecutions they took over in 2015? This might give a steer in relation to the number of private prosecutions. Ditto FACT and the RSPCA. Now, I'm not sure that freedom of information would work on FACT and the RSPCA because they're not government bodies. But yes, you could, and the CPS would obviously be able to tell you how many they were aware about. But actually, I don't think that would give you a real knowledge of how many private prosecutions there were, because quite frankly, the CPS are not aware of all private prosecutions. There are a number of reasons why a private prosecution might come to the attention of the CPS. Those are, one, either of the parties makes them aware of it, two, the court makes them aware of it, or three, that there is sufficient well, there's some other reason. So there is it's publicised in the papers or something like that. But if one of those doesn't happen, CCS simply don't get to know about private prosecutions, and therefore their records, even if you obtained a freedom of information or you served a freedom of information request on them, would not be complete. I'd have thought the the Office for National Statistics should keep some record of these, but they don't. I've had a look. So at the moment, it is a case of simply not knowing. The indicia in the market are certainly that there are a number of private prosecutions, and the number of them are increasing. So I certainly think it's something for clients to be aware of and to consider when they're facing a situation where they have been defrauded. David Ingram has also quite rightly indicated that compensation relies upon the predicate crimes being proved. Yes, entirely they do. The compensation and confiscation regimes only work where you have proved the crimes on the information in the summons. But in truth, that's not really any different from the situation in the civil proceedings regime, because unless you prove your case, you prove the fraud, you are going to find that if you had obtained a freezing order or an interim freezing order, you're going to find that is discharged, and you're ordered to make good under the cross undertaking. And equally, you're not going to obtain a judgment to enforce in any of the ways that you would normally be able to enforce them. So it applies across either regime. Unless you prove your case, you're not going to be able to harness the benefits of the schemes to try and enforce. The point that I think is important, though, is that in the criminal justice system, in the compensation and confiscation regimes, to a significant extent, the burden of doing the investigating as to assets is switched over. It's on the defendant rather than on the claimant/victim, which is it's got to be quite an attraction for anyone faced with having to bring fraud claims. So I think that's all the questions that have been made. We've also run a little bit over time. Let me finish by thanking you all for joining me today, and I hope you join our next webinar in this series, which is called When a Regulatory Inspector Comes Calling, and that's on the 24th of September. Thanks.